Hello. Now, in this module, we will study laws, stamp, and intellectual property under mergers and acquisitions. We know that primarily for mergers and acquisitions, the act which is kept into mind is Indian Companies Act of 2013. And in this act, sections from 230 to 234 define actions and omissions or the procedure or the requirements. Those need to be carried out. But this act does not define mergers or acquisitions. Like, take an example, like here the merger has not been defined, but the word offer, acceptance, agreement, contract, all these words have been defined in the Indian Contracts Act. So, mergers and acquisitions, though have not been defined, but a description is there, how to bring about merger, what are the provisions. So this is a description and not definition. Obviously, we can create a proper definition when we know the meaning, when we understand, when we get the sense of something, then we can put it into words, so it can be put into words. But the Act itself has not provided any definition, but we can understand it. And we need to consider these sections from 230 to 234. But apart from this, as NADs cover many things, those are relevant to other authorities and other acts as well, like the FEMA Act, like the Competition Act, and even guidelines by authorities like the RBI, like the SEBI in case of publicly listed companies, and by NCLT as well. There are so many guidelines. So those things are also to be kept in mind along with the central as well as state legislations. Those come up from time to time and keep on changing from time to time. There are many amendments, those are made. So we need to keep those in mind as well. And we need to keep ourselves updated always. Now, there is one important scenario in case of publicly listed companies, that SEBI created a takeover code that is called Substantial Acquisition of Shares and Takeover Regulations of 2011. Now, the purpose of this code was to prevent hostile takeovers and at the same time provide some opportunities of exit to the innocent shareholders. So it is facilitating the innocent shareholders. These are generally those shareholders who have purchased share from the market or through stock exchange. They trade in stock exchange or might have brought small amounts from the public issue, IPO or FPO or whatsoever. Now, so this facility was provided under these regulations of 2011. Now, with this code coming up, the promoters of the company as well as other shareholders who are smaller shareholders who trade in the market, who have purchased from shares from the market from IPO or FPO, whatever the case is, so they get the same amount on sale of shares. It is not that promoters can take higher amount. Now, another thing which SEBI has done is that under such agreements of mergers and acquisitions, there was a non-competition clause, because the promoters can easily establish another company and compete with the business they have sold, and they are expert in that business because they have promoted the business, they can again do it. So there was a clause that is generally and almost every time there is a clause that the sellers will not compete, and for that clause the promoters used to charge, and this could be as much as 25% of the public offer price. So they were charging, but a shareholder is a shareholder, whether he is a promoter or a public member, any public member who has purchased shares from anywhere. But why only promoters were getting a higher amount? So SEBI said that nobody will get anything, so do not charge for non-competition or not competing. So these were some important laws. Apart from this, there are several laws which we have already studied in the previous module. So that is a detailed study in the previous module, and along with that, the manual that you have got, the student's manual, which is in PDF format, it covers up everything. So once you go through it, there is very detailed description. It is very explanatory that very easily everybody can understand. So go through that and you will be understanding everything, as it is very easy and very self-explanatory. Now let's come up to stamp duty in M&A deals. Now, when we are talking about mergers, acquisitions of any sort, now directly for mergers and acquisitions. Now, if any fees is paid by any organization when we apply, then it might be chargeable like by NCLT. But we are talking about stamp duty. As we know that when something of high value is sold, stamp duty is paid. Suppose you sell land, you sell a building, you register it, and once you register it, you need to pay. And because you are registering, there is a deed created, and you are registering it. So you need to pay some stamp duty. So here also, you need to pay stamp duty, and this is a state-specific matter that is local to states like Delhi, Maharashtra, Tamil Nadu, Karnataka, and West Bengal. So this way. Now here the stamp duty is not paid on the company. This stamp duty that we are talking about is not paid on merger or acquisition. But as we know, there are different types of mergers where specific documents are created or these instruments are created. And for creating those instruments or documents, there are charges. Now let's take examples where these duties can be share purchase agreement or business or asset purchase agreement, indemnity agreement, demerger, merger. Now let's take example of share purchase agreement. A share purchase agreement is such a document that creates a sale and purchase between buyer and seller. Now, as this is a state-specific matter, let's take an example of Delhi. We are taking example of one state, Delhi. Now, in Delhi, Article 5B of Schedule 1A of Delhi Stamp Act states that stamp duty on the agreement or memorandum of agreement related to sale of share of an incorporated company or any body corporate is 1 rupee for every 10,000 rupees. So this rate comes to 0.01%. And there is also a cap on it that the duty cannot be more than 1,000 rupees. Now, share transfer forms. This is another document or instrument. Then for this, Article 62A of Schedule 1A of Delhi Stamp Act states that stamp duty for transfer of shares of any incorporated company or any body corporate without consideration is 75 paise for every 100 rupees. Now this rate comes to 0.75% of the value of shares. Now why consideration is whether paid or not paid, this stamp duty is chargeable. Now why consideration is not paid? We pay consideration when we sell, but this is for transfer, whether it is transferred by sale or you gift it to someone, you are not charging anything. Like in income tax, someone has got gift, then gift tax is payable. General income tax, though, might not be payable. So here also, it is saying that the duty is the same. That is 75 paise for every 100 rupees. So that is 0.75 of the value of shares. So this stamp duty will be payable on transfer, whether consideration is paid for those shares or it is not paid. Then asset purchase agreements or business transfer agreements. Now, under business transfer agreements, like if a person is selling their business and does not want to remain with the business, that is that he is not selling a portion of or a part of the company, but selling the company entirely. So everything of the company, whether assets, vendors, liabilities, clients, everything has to be passed on or transferred or given away to the person or the company who is purchasing it. So under these circumstances, like we take example of Delhi, Article 23 of Schedule 1A of Delhi Stamp Act mentions the stamp duty is 3% of the consideration amount set forth in the instrument. The stamp duty is reduced to 2% in case the buyers are women, individual women or women. So it is reduced to 2% for them. Now in case of industrial machinery, like if somebody is selling land, there is also some machinery which is permanent, which cannot be removed. Just like if you are selling a land and you have created a building on it, so you cannot separate them. If you remove building, then it will get destroyed. The same way, let's take an example of a factory. Let's take an example of a textile mill. Somebody is selling land on which the mill has been built, but this erection or this establishment, which is mill, is on it, and it is also getting transferred to the buyer. So it is considered like a permanent thing, like a permanent building on land. So this way, and then it is charged accordingly. Now, if there is immovable property, there is another duty. Like duty is 3% in case of movable property and 5% in case of immovable property. So we are taking the example of Delhi in this case. Then there is stamp duty on indemnity. Like there are some shareholder agreements or share subscription agreements where there are indemnity clauses. So under that clause, because it is there is an indemnity clause, so it is an indemnity instrument. So these net need to be stamped accordingly, and the appropriate stamp fees is payable according to your state. Then there are demergers and mergers as well. So different duties are payable according to the scenario, and it is not necessary that this is in the case of body corporate. So here there can be other sort of establishments or a constitution as well, because these days we also know that OPC or one-person company has also emerged. It is also a company after all. It is included in the corporate sector. Then there is limited liability partnership. It is considered like a company, though it is partnership, but acts just like a company because there is limited liability, just as it used to be in companies, but it was not for partnerships, but now it is for partnerships as well. So partnerships can be limited liability or with unlimited liability as well. Now, let's study intellectual property in mergers and acquisitions. Now, these days we see so many intellectual advancements are going on. Everything is tech dependent. Everywhere technology is being used. And there is so tough competition that people are trying to improve more and more on technology and other intellectual properties as well. So this is very important for lawyers, because when intellectual property is involved, lawyers need to understand the role of intellectual property in a transaction and laws pertaining to intellectual property as well. And acquiring an intellectual property asset in a merger or acquisition transaction helps the company growth. Why? Because of this new technology or a superior technology. So companies' assets will increase, or company's portfolio will be enhanced with this value, because it is a valuable thing. And intellectual property is a valuable thing. So, and with this intellectual property, if say we are taking example of some technology that is being used in the company. So if such company is taken over or merged with, then a new value of the entire company is created, because now it has merged or got acquired by other companies. So now the remaining company, so that or the existing company, the value enhances. The combined value of these companies would have been lesser, but now it will be more, because all the sorts of expertise have increased. The market has also enhanced in case all were into the market. Or if there was a manufacturing company which was using technology, then it was not a marketing company. So this was a problem with it. It has merged with a marketing company, so value will increase. So this company will not only earn from the purchaser of goods or services, but also earn from sale of its shares, because shares are traded. So the value will increase. So the motive of the shareholders is to earn money. So whether earn from customers of products or earn by selling the shares. Intellectual property also creates royalty. Like if somebody else wants to use that technology in some other area, then the company can allow it and keep on earning royalty from the company which is using, like Oxford AstraZeneca was used by this Serum Institute for Covishield, so it was paying royalty. So this way, royalty can also be earned. So it's consistent. So because these there are patents, and patents are generally for 10 years to 20 years. So during that period, royalty can be earned easily. Now let's understand what are the types of intellectual properties. There are 4 major types of intellectual properties. Now patent is the first intellectual property, which is most widely discussed. Now this patent gives the right to the inventor that only that inventor or whosoever applies for that patent, generally inventors do, so that inventor will only be able to use it in order to manufacture things according to the patented technology, or he can only allow others and take royalty. So patent law is generally valid from 10 to 20 years according to the country. So during that period, the inventor or whosoever he has authorized can earn. And there is general patent as well worldwide, but general patents are difficult to implement. So what people do is, for every country, people individually apply at their patent offices, like distinctly for Japan, distinctly for China, distinctly for Russia. So but a lot of money is spent on it. So there is a general as well, but general, most people in the market say. What is the real scenario, we do not know, because many people are happy with it and many people are unhappy with it. But it is a general notion that individual patents filed with individual countries are more beneficial or handful, or are more impactful. But in order to save money, people may go with the general international patent, but it is said that it is difficult to implement, because then the country might listen to it or not listen to it. So that is another thing. So that is a controversial matter, but we are in the market, we need to know these things, because if we are studying these things, we will be working on these things. So we should be aware that these things also take place in the market. Now, then there are trademarks. Trademark is a mark after all. So anybody can use a trademark, but if somebody is using trademark and other person is using the same thing, then the person who is already using that trademark will suffer losses, because others are also using it. So it is a protectable thing. So it is also considered as an intellectual property. But as these trademarks are somehow different, because unlike patents, trademarks cannot be sold, but that ownership can be transferred along with the product. So this is the difference. Then there are copyrights. Copyrights are given by the creator to other parties. Otherwise, the creator himself is holding the copyright. If he gives copyright to others, then others can copy his material, and otherwise they cannot copy his material. The Copyright Act of 1976, as amended from time to time, obviously, protects the copyrights in India. Now, there are trade secrets, formulae, like we can take the example of like Pepsi formula or Coke formula. So this formula is that trade secret. So this they do not disclose to anyone. So this can consist of some formula of creating something like Pepsi or Coke, or maybe like Tesla Motors, and maybe some design, like design of a machinery, maybe some algorithm of some program or software, or there may be some pattern that is followed during some process. But these trade secrets are for unlimited duration, because this you keep as secret. So when you are keeping it as secret, so it will remain with you only. So these are forever. So companies keep these things, such trade secrets, with themselves forever. Like Coke is still keeping it, Pepsi is still keeping it. So companies are still keeping it. Several years have passed, several decades have passed, but they are not disclosing it, and they are keeping it secret. So this was about intellectual property. Now we have understood what intellectual property is and how it is secured, and this sort of work is also carried out by the lawyers. So you need to understand this. You can take this distinctly as well, not necessarily under mergers and acquisitions, but otherwise as well, you can take it individually. So in that way, this will be helpful for you.